All right, good afternoon, everyone. Just a couple of announcements I want to make for next week. May 7th, Tuesday, movie night with pizza at 5:30 here at the Senior Center. There is a sign-up sheet on the bulletin board for that. And Twins is the movie. Also on May 7th, chocolate-covered strawberries from 1 to 3 p.m. here with Sally. So if you're interested in doing a little crafty thing with food, that's going to be happening next week as well. The sign-up sheet's on the board for that. And then next Friday is our Mother's Day party as well. So you're certainly welcome to sign up for that too. So today we have a speaker, Ralph Tepper, an elder law attorney, will be presenting to us. And again, we welcome Mark Montminy, our chief and acting town manager. He's my boss right now. So we always welcome the chief and Jean. All right, so let's do a moment of silence, please, before lunch. All right, thank you. Enjoy your lunch. We're going to serve first, and then Mark will be introducing our speaker. Thank you.
Okay, ladies and gentlemen, we're going to get started with our program. For those of you who don't know me, my name is Mark Montminy. I'm your chief of police, and as of Friday, apparently, also your town manager. For those of you who don't know, our town manager departed abruptly, and they asked me to stand in for her as town manager. It was going to be either me or Jean, and Jean said she wouldn't do it, so I took over as town manager for a couple of weeks, and the timing couldn't be worse because town meeting's coming up in a couple of weeks, and so I got a lot of work to do, but I didn't want to miss today because, of course, today is Sally's birthday. So we wanted to make sure that she's 21 today, so she is able to drink now. That's good. That's good. So a couple of people took pictures of me with the cocktail here. Don't anybody post that on Facebook, please. What happens at the Senior Center stays at the Senior Center, right? It's just like Vegas. So today we have a rare treat for you. We have Attorney Ralph Tepper is here. He is an elder attorney in private practice in Mendon, and he's going to talk to you a little bit about legal affairs that are of particular importance to people who are elderly. Ralph?
Thank you.
Don't get too close to the speaker.
Well, thank you, everyone. Thank you, Lisa, for inviting me, and Chief, thank you very much for the intro. And there's this parking ticket I have. Maybe we can talk up louder. Better? I understand. No problem.
Especially with all the margaritas.
So what I'd like to take the opportunity to do for you today is just to go over what I consider some basics. When it comes to estate planning, which is the overarching description of what I do, a large component of that is dealing with what's commonly called elder law issues. Those are issues that really affect people that are retired and post-retirement. Estate planning is a process, and it changes depending upon the stage of life that a client is in. I have clients that are individuals that are young. I have young couples with children, and I have a number of folks my age and older. So in that setting, there are 3 or 4 things that I'd like to take a minute or two to talk about that are just very, very important. They may be things that you're familiar with. There may be things that you already have in place, and if both of those are true, that's wonderful. But if they're not, I would suggest that you think about these. Will do. Thank you. The first of these is something called a healthcare proxy. That's a document that allows someone to appoint an agent, someone to act for them. if they're determined not to be able to act for themselves. This allows somebody to make healthcare decisions for you if you're not able to make those yourself. Why is this important? Because lacking that piece of paper, somebody's going to have to end up in the probate court asking for a guardianship or a conservatorship to be able to make those decisions on your behalf, and you're not absolutely sure who that's going to be. With a healthcare proxy, you can choose who that person will be. You can also choose a backup to that person, someone who would act if your primary agent isn't able to act for you. Typically, with couples, we have husbands acting for wives and vice versa, and generally, one or more of the children is a backup. So a healthcare proxy, extremely important. Everybody over 18 really needs to have that document. And I know Lisa has heard this before, but I have two daughters. When my eldest daughter turned 18, she was away at school. And when she came back on spring break, I had healthcare proxies and the next document I'm going to talk about prepared for her to sign. And the reason for that is she's 18. She's an adult. If her mother or I needed any information about her health situation, if she was hurt or injured, she was going to school out of state, medical providers wouldn't talk to us, even though we're her parents, because she's over 18. So we finished doing a healthcare proxy and a power of attorney for her at one of my colleagues' offices. And when we were finished, we were about to go, and I got this typical 18-year-old sigh. And I said, Alyssa, what's the question? She said, well, Dad, I understand all of this stuff, I think, but my real question is this all I get for my birthday? The answer was no, but no ponies. The other document is something called a durable power of attorney. And that's similar to a healthcare proxy in the sense that it's an agent relationship. But powers of attorney deal with every other part of your life except medical decisions. And if I were to try to give you an overview of what it covers, I'd say property and dollars and cents. Anything that has to do with any of those things is what a durable power of attorney covers. Similarly, if one does not have one of these, if they have a bank account in their name, if they have an IRA, if they have a life insurance policy, if they own real estate, nobody can deal with those assets on your behalf if you're not able to deal with them for yourself. Once again, another trip to the Worcester Probate Court if those documents are lacking. They are the most important two documents that an individual can have. They're more important than a will, frankly. In Massachusetts, if you don't have a will, the Commonwealth of Massachusetts has an estate plan for you. It may or may not be the estate plan you want, but there is a plan. And someone will implement that plan for you. But with the healthcare proxy, with the power of attorney, if they're lacking, they're not in place, the court's going to appoint somebody to deal with you from a medical perspective, a personal perspective, and a property perspective. It might be a relative. It might not. It might be someone appointed by the court. It might be a stranger. And besides being very inconvenient, it's also tremendously expensive. Because if that person isn't a family member, they're going to be paid. The court is involved in every decision that that individual makes for you. Some people call that a living probate, and that's something to be avoided at all costs. It's not a big deal to put these two documents in place. The fees are not significant. But when you look at them in comparison to what could occur if you don't have them, it's a very, very wise investment. The other area of my practice that I deal a lot with in the elder law community is protecting assets. Everyone, I'm sure, knows someone or has a family member that might have unfortunately ended up in long-term care. In those circumstances, there's really two sources that cover that kind of care. It's your pocketbook or it's the Medicaid program. Unfortunately, the Medicaid program is not like Medicare. Everybody is not entitled to Medicaid. Everybody over 65 is entitled to Medicare. But it's Medicaid that pays nursing home costs. Medicare does not. And unfortunately, to qualify for Medicaid, there are asset limits, and they're very, very, very low. For a single individual, $2,000 is all you can have before you can qualify for Medicaid. Now, there are some circumstances where a house, if it's a home you live in, may not count towards that threshold, but there are complications with a home, even if it doesn't count as an asset. So I deal with a number of clients that want to look at protecting assets from having to be spent for that purpose. And I'm sure everyone's heard the radio commercial on WBZ from my good friends, the Commonwealth Advisory Group. Well, that's advertising. That's not reality. It isn't as simple as sitting in an office, signing a couple of pieces of paper, and everything is taken care of. It's really a discussion that has to be had by the client, sometimes the client's family, because in order to protect things, you have to restrict your ability to do things with those assets that you would otherwise be able to do freely. So, as they say, and I don't mean it for today, but there is no such thing as a free lunch. If you want to protect assets, you have to give things up to do that. But you also have to face the 5-year look-back period. If you take action to protect assets, you have to wait 5 years, if you can, before you need long-term care. If there's a problem and you need that care inside that 5-year window, there's going to be a set of issues that need to be dealt with to determine whether you can in fact qualify for Medicaid to pay for those nursing home costs. Private payment for nursing home in Massachusetts is incredibly expensive compared to most parts of the country. The average cost of a day of nursing home care in Massachusetts is $354 a day. That's the average. I can tell you that for most of the facilities within a 5-mile or a 10-mile radius of where I'm standing, it runs about $375 to $450 a day. And that's a tremendous amount of money to pay out of pocket. Other instances are when a family has a loved one in long-term care and they're actually paying out of pocket for it. There are still things that can be done at that point in time to potentially protect assets from having to be completely spent for that purpose. It's beyond the few minutes that I would have here to be able to describe that, but if anybody is interested, I'm happy to speak with them. I know Lisa is very kind in giving my name out to anybody that has questions or issues, and just from a general perspective, I never charge anyone for an initial consultation. So, especially somebody from our good friends at the Senior Center. I also deal a fair amount with families that unfortunately have what are called special needs children. Those are children that have some level of disability that entitles them to get primarily Medicaid benefits to cover health care costs. Those types of situations can be very devastating financially for a family, and there are ways to put aside assets, to protect assets, so that that individual can continue to get those public benefits that he or she is entitled to without having to be completely impoverished. And that's a fair, significant area of my practice as well. So these are just some of the very, very basics of actions and things that folks need to think about from a planning point of view. And for whatever time I may have left, if people have questions, I'm more than happy to answer whatever I can, so feel free. Good enough. Everybody's more interested in lunch and dessert. That's fine. Thank you very, very much.
You got an attorney here who's willing to answer your questions for free. Nobody's got a question? Oh, we do. We have one question. Hold on a second. I'm going to bring you back for an encore here.
All righty. Yes.
I have my money in the trust with my son, not in trust, in both our names.
Yep.
Now, when I die, will he be able to just take that money?
So the question was, someone was asking about what's called a joint bank account. And that's an account where an individual has someone else as a joint account holder. That individual is someone, it could be a spouse, it could be a child. That individual owns that account to the same extent that the original owner of that account owned it. So there's some implications to that. The specific question was, what happens to it if one of the joint account holders passes away? And the answer is that account automatically becomes the account of the survivor. There's nothing that has to be done except presenting a death certificate to a bank. However, I've run into too many clients that have used that approach but didn't understand the implications of that approach. So in an estate planning perspective, oftentimes clients put children on those bank accounts so that that child can handle that account for that individual if either they can't or they don't want to, and they would prefer them to handle it. And that's perfectly fine. However, let's assume this is an account that has significant value in it. And let's assume that the individual passes away. And let's assume they have a will. And their will says everything gets divided equally between our children. Well, this particular account doesn't get divided equally between the children because it's set up as a joint account. If you want to have those types of assets distributed to all of the individuals that your will specifies, you don't want to have it as a joint account. That's where you use a power of attorney. You still own the account, but you can add someone on the account through the power of attorney. They can manage the account, they can handle the account, but they don't own the account. So if the primary account holder passes away, that account is going to go wherever their will directs it to go in whatever proportions they so direct it. Too many times I've had an estate that I was handling for a decedent. There was a significant bank account that was jointly owned. There were other assets through the will that were left equally to the children. And suddenly there's a rift in the family because Johnny got the $200,000 account that was the joint account with Mom, and the rest of the kids got little or nothing. So you need to make sure that you're titling an account for the right reason. If it's simply to have someone help you with it, you should have a power of attorney and allow that to be the tool. So I hope that answered your question. You're welcome.
I have a question. What if you want to,
Yes.
and you know, a lot of people say, put your children on the names of your house.
So the question was in the context of a home. Several people may have had the thought of, I'd like to just put my kids on the deed to the house. Well, that's really not a very good idea. And it's not a good idea for the following reasons. If you put if you transfer your home to your children, you don't own it anymore. I'm sure they're all good kids, but someday they might decide they'd rather sell that house, and you're out. That's a bad thing. Number two, even if that never occurs, if those children own the house, if something happens in their life, they get sued, they get divorced, a bankruptcy, that's their property. It's not your property, and your property is now at risk. So when we do that type of planning, particularly with real estate, particularly with a home, the vehicle that we like to use is a trust, because the trust will insulate that property from anything that can occur in the children's lives that would otherwise impair your ability to stay there and live there. So giving the house to the kids theoretically is a nice thing, but there's a right way and a wrong way to do it. Hope that helps. Yes?
Can you state the difference between irrevocable trust and just a trust?
So the question was, we have all kinds of different types of trusts, and we have what's called a revocable trust. And as that name suggests, that trust can be changed at any point in time, in any way, by the person who created it. In the world of Medicaid planning, revocable trusts don't do anything positive, because from the Medicaid agency's point of view, the property is in a trust that you completely control. Therefore, it's still your property. The other type of trust that's used, and the trust that's used exclusively for Medicaid planning, is something called an irrevocable trust. And that's a trust that once it's established, it can't be changed. That sounds constricting, if you will, and it is for a reason, because if you could change the trust, it wouldn't protect the property that's in it from nursing home costs. So that's part of the trade-off that clients have to think about before they decide to do this kind of planning. I hope that answered you.
Is that part of the 5-year look back?
Well, the question was the 5-year look back. You need to understand that from two different perspectives. If someone is looking to qualify for Medicaid benefits and apply, the date that they want those benefits to begin, 5 years backwards in time, is the 5-year look-back period. When an application is filed for these benefits, the agency requires 5 years of financial records to be submitted with that application. And they're looking through those records to see whether the applicant or the applicant's spouse gave away anything during that period. If they did, and they consider it a disqualifying transfer of assets, those benefits are going to be delayed for someone, perhaps for a long period of time. The look-back period also is in the context of doing advanced planning. Advanced planning meaning, I'm not in a nursing home, I don't expect to be. I want to look at protecting assets today. Once you make a decision, and if you do move forward and make that decision and transfer assets to protect them, the clock, if you will, on that 5-year look-back period starts to run. So that if you end up ultimately applying for Medicaid, and the day you want your benefits to start is 5 years and a day from the time you transferred those assets, you're past the look-back period, so it doesn't affect you. I hope that answered your question. Yes?
A will or a trust? Should you have both? Should you have one or the other depending on your circumstance?
You should always have a will. A trust may or may not be the right thing to have. It all depends on a client's circumstances and what they're trying to achieve. Going once. Going twice. Back to the chief.
Thank you. Wasn't that great, folks? Don't worry, he'll be back.